Ellarigu Namaskara. A very good evening to each one of you. On behalf of Bangalore Chamber of Industry and Commerce and Karnataka Employees Association, we welcome you all for this exclusive session on the implications on recent Supreme Court judgment on pension scheme. We are beholden to Mr. B.C. Prabhakar, who is the mentor of our HR expert committee, for structuring the session. Thank you very much, sir, for your support. We also welcome all our past presidents, our office bearers, leaders of the expert committee, and the distinguished participants for this session. The session is organized under the aegis of our HR and Women Leadership Expert Committee, chaired by Dr. Augustus Azaria, who is the Vice President HR of Kendrill, co-chaired by Ms. Ramani Ganesh, and Ms. Anuradha from TVS and Hirect, and mentored by Mr. B.C. Prabhakar, who is present here. On behalf of the Chamber, we welcome Mr. Devappa Gowda, who is the advocate at BCP Associates LLP. Thank you very much, sir, for accepting our invitation to address our members over this session. The Chamber acknowledges the support of its member organizations for their sponsorship for all the events during the year. They are Bueller, Fundramax, IAMPL, MTR, Sona Group of Companies, SDMIMD, TVS Company, Motor Company, Vishwas Group, and Wipro. Now I hand over the platform to Mr. B.C. Prabhakar. Over to you, sir. Thank you.
Thank you, Rupa. Friends, Ellarigu Shubha Sanjay. Good evening to all of you. Am I audible?
Yes, sir.
Okay. I also join Rupa of Bangalore Chamber of Commerce to welcome all of you on behalf of Bangalore Chamber of Commerce and also on behalf of Karnataka Employees Association. I am President of Karnataka Employees Association and also Management Committee member of Bangalore Chamber of Commerce. I am also a member of BCIC HR and Women Leadership, mentor of BCIC HR and Women Leadership Expert Committee. Dr. August Azaria, Vice President of Mrs. Kendrill, Chairman of the said committee. Friends, as soon as the judgment of Supreme Court on PF pension issue was rendered on 4th November 2022, many queries were posed. Mr. Murali, who is executive of Toyota Shushu and President of Bidji Industries Association, a member of Management Committee of BCIC, and Dr. Augustus Azaria discussed with me to hold a webinar. I was also contemplating to do so from Karnataka Employees Association. Then we agreed to have a joint webinar and immediately circular was sent. I am happy to note that more than 10 delegates have registered not only from Karnataka but also from various other states. This shows the importance of today's webinar. Friends, the subject of pension has a checkered history. Pension facility was introduced for the first time in the year 1995 under the EPF and Mutual Provision Act 1952. Initially, the coverage limit was Rs 5,000. Thereafter, the Government of India brought amendment to the Employees Pension Scheme by notification dated 22nd August 2014 and also enhanced the statutory wage ceiling from 1/9/2014 from existing limit of 6,500 to Rs 15,000 per month. Consequently, certain amendments were also inserted to the pension scheme. The above amendment gave rise to several doubts and confusion in the minds of the members of the Employees Pension Scheme, and they challenged the amendments before the different high courts. The high courts of Delhi, Rajasthan, and Kerala struck down the notification dated 22/8/2014, particularly with respect to the amendment to the pension scheme. The controversy has been set at rest by the recent decision of the Supreme Court decided on 4th November 2022. The present seminar has been organized to understand all the implications of the latest judgment of the Supreme Court. So we have my colleague, Shri C.K. Devappa Gowda, advocate, and he is practicing in the law chambers. He has tremendous experience related to PF matters. We will take you through the complete details of the issues involved and the implications of the judgment of the Honorable Supreme Court in the matter. But Mr. Devappa Gowda is also an advocate. Earlier, he was working for Punjab National Bank. After retirement, he has joined me, and he deals with the PF matters actually. And we have also my colleague Mr. Vasiki, who will moderate the event. Mr. Vasiki is an advocate who is also my colleague. He is also handling PF matters, and he will handle the question and answer. In fact, Mr. T.K. T.R. Parashuraman, part student of BCIC, so when R.C. Gupta case was decided by Supreme Court, he was talking to me also, and he has he raised a lot of questions also, and he is also here. I'm happy that he is also here. He wants to talk few words. He wants to express his views, and thereafter, Mr. Vaski will take over. Thank you all. Mr. Parashuraman.
Very good afternoon, Mr. Prabhakar. Thank you very much for, thank you, sir, for initiating this very, very important topic. I would like to place it on cards, my sincere appreciation to Mr. Prabhakar, the President of Karnataka Employees Association, the mentor of Bangalore Chamber of Industry and Commerce, the Human Resources and the Women Empowerment Committee. I would like to personally thank him for this, along with Dr. Augustus, I think, who has been guiding the HR committee from time to time. He has been chairing our HR committee. Thank you, Dr. Augustus. And also my special thanks to Mr. Murali for taking this forward and initiating this timely meeting. So at BCIC, in fact, this topic was very hot, and we discussed it even a couple of years back when the Supreme Court judgment was in the kind of abeyance. After the Kerala High Court order was there, then it raised a lot of doubts among the member companies, and many questions were raised. And in fact, I was also discussing with Mr. Prabhakar. And after a very long time gap, the breakthrough judgment has come. See, the key point here is we need to understand this judgment very carefully, because person to person, it may have a different implication based on the number of years each person has put in the 95 scheme of pension scheme, and again a company contribution, then whether they're contributing on the full amount or on the kind of statutory limit. And again, the challenge is the window period is open only for 4 months now. So the 4 months already the time has started. So it is very important for members to understand, then understand their own risks associated. Then also check up with the past records, because I'm also wondering, I've been also in discussions with Mr. A.K. Singh, is my good friend, the current Provident Fund Commissioner, Regional PF Commissioner, and Mr. Narayan Kamar, the past Commissioner. I think, a lot of challenges are there. First of all, we need to get an official order. In fact, today morning, I could see the paper advertisement from Haryana, I think Punjab and Himachal Pradesh government. I think similar, ad has to come from various commissioners. I think I'm told Chennai also has come. Mr. Prabhakar was mentioning. So I think we need to get it from government of Karnataka PF Commissioner also as quick as possible. Then we have window period of only 4 months, which means within 4 months, each member, together with their employees, have to give the declaration. In fact, we have got some sample format also now going across. So I think we can use that kind of format. And each person's mitigation, for risk mitigation, we need to understand based on the kind of number of years put. And some people would have already resigned or they would have completed service. After 2014, of course, people are eligible. So again, the pension due date again starts from 95 and it is over by the age you retire, is what I understand, the age of 58. Which means after 58, people are eligible to get pension if you are going to enroll in the scheme. Then again, not only the pension, we need to pay the arrears of 8.33% of the employer's contribution, plus the interest due from the time of retirement. So this, each person has to calculate for himself and understand the risk mitigation. So it's a very important subject. And then again, 2 years of service weightage given about 20 years, and also So this kind of a finer details, I'm sure today Mr. Devagowda and Mr. Vasugi, I think they will share their thoughts on this. I request all of you to raise as many questions as possible, being a very, very important topic. And more we raise the questions, more clarification we get so that we can take it forward. So I wish this session a very, very happy one and a value-adding one. Once again, my special thanks to Mr. Prabhakar, Mr. Augustus, and Mr. Murli. Thank you so much.
Thank you, Mr. Raman. In fact,
Thank you, sir.
we are happy to inform that our additional Labour Commissioner, Dr. Manjat, also joined the webinar. He is a person who very deeply studies all the issues pertaining to labour laws, and I am happy to see him. And he's also joined. And in fact, a lot of people would be asking him also, and he is keen to understand these things. Welcome, sir. Thank you. So over to Mr. Vasuki. Mr. Vasuki. Unmute. Vasuki, unmute.
Good afternoon to all of you. Thank you very much, BCP sir. Welcome to all of you once again for this very important webinar. See, the question of pension always generates anxiety. Everybody would be interested to know the quantum of the fruits of their savings that will help them to negotiate the twilight years of their life. So, therefore, it is no wonder that this webinar has generated so much of response, which has been jointly organized by KEA and BCIC. Now, to decode the latest Supreme Court judgment on this issue, we have Sri CKD Gowda, whom I affectionately call as the walking encyclopedia on labor matters in general and pension in particular, who will take you through the nitty-gritty of this judgment. Thanks to the efforts of BCIC, we have received a large number of questions running into 6 full-scale pages already. That itself shows the amount of anxiety and interest that people have shown in this subject. My request to all of you is that if you can give your undivided attention to the presentation that is going to be made by Gowda sir, I can assure you most of the questions that you have sent will be answered already, because the presentation prepared by Gowda sir is extremely exhaustive, and I'm sure it is going to answer most of your questions. Of course, we are still going to have a question and answer session at the end of this presentation, which will, of course, clarify further doubts if you have, if any. So with this, I thank all of you once again for participating in this important webinar, and I request Gowda sir to start the presentation.
Good evening to all the participants. I thank Mr. Prabhakar sir, Mr. Raman, and also on behalf of our friends here, I once again welcome Additional Labour Commissioner Dr. Manjunath, who is not only one of the efficient officers in the Labour Department, but a good friend of everyone, employer and trade union leaders. So that is the speciality of him. Yes. As far as reverting to the today's program, it is a very interesting program for the simple reason that it affects the pensioners. It affects those who have worked for long years and contributed to the Provident Fund, and they are awaiting to get the fruits of their investment in the pension fund. Well, there had been certain hurdles in getting these pensionary benefit, but all those hurdles have been set at rest by the judgment of the Supreme Court, which we are going to discuss in detail. Before we go to the actual listing, etc., we have to answer for ourselves certain questions, which will be the context of our webinar today. And during the course of the presentation, we will almost answer all these questions which have been raised before you. For example, for the first question, everyone will be interested to know is that who will be benefited by the recent judgment of the Supreme Court for claiming higher pension and the period for which he can claim. How can one opt for pension contemplated under paragraph 11.3 and paragraph 11.4 of the employees' pension scheme? How to opt for higher pension within 4 months from 4/11/2002. This is most important in the sense the time limit for exercising option is only 4 months reckoned from 4/11/2022. This all of us should, those who are in the want to avail the benefit of the scheme should make a special note of it. If EPFO does not consider the joint option exercised by the employer and the employee or fails to sanction higher pension on any other ground, whether legal remedies are available to the pensioners, whether an employee who has not given option but deposited higher EPF contribution over and above the statutory limit of salary may claim the higher pension. If yes, what is the procedure he should follow? Whether an employee who has not opted and not deposited higher contribution to the provident fund more than the statutory limit is entitled to the benefit of higher pension. This is one question which is being repeatedly asked from us, from the level people who had not made additional contribution, but now because of the judgment they are interested to avail the benefit. Unfortunately, they can't do so. Yes. The point frame for discussion and deliberation are as under. This webinar is being held to understand the implication of the judgment of the Supreme Court on amendment to the or consequent amendment to the pension scheme. To understand the judgment, it is necessary to understand the pension scheme as introduced in 1995 and amendment to the para 6 and 7 of the pension scheme in 1996, which has been a subject matter of the decision in the case of R.C. Gupta. But everyone should know that though the R.C. Gupta case has been upheld in the present judgment of Supreme Court, but it related to the period prior to 1/9/2014. Amendment to para 6 and 11 of pension scheme in 2014, subject matter of decision in the case of EPFO versus Sunil Kumar, etc., which we are going to discuss in detail, and it is the main topic for discussion. The employees' pension scheme is in fact a part of the schemes contemplated under the EPF Act. And the Employees Provident Fund and Miscellaneous Provisions Act came to vote in the year 1952, whereas the Provident Fund scheme was introduced later after 1 month, in which the starting salary for the purpose statutory limit was only 300 rupees. And it has been enhanced from time to time, and the present wage limit is 15,000, but this has been amended and enhanced over a period of time 8 times. Well, those nitty-gritty details we are not going into it. We are straight away going into what the pension scheme says. Employees' pension scheme was formatted by Government of India in excess of power conferred on it to amend the Provision Section 7 of the Act, which was inserted in the year 1995. This employees' pension scheme came as a matter of replacement of employees as a family pension scheme, which came into force in the year 1971. This pension scheme stipulated that, you see, its pension scheme is again did not call for any additional contribution by the employee or the employers. What it said was that whatever the contribution you are making, that is 12%, 12% of the employer's contribution will go to the Provident Fund, will be diverted to 8.3% out of 12%, will be diverted to the pension fund. And similarly, as the balance of 3.67% would remain in the Provident Fund, it becomes a part of the employee's contribution to the Provident Fund. In other words, only 8.33% of the employer's contribution was going to the pension fund, and employees' contribution remained in the Provident Fund. During 1990, at the time of formulation of pension scheme, the statutory salary limit for coverage was only 5,000 rupees. That the said amount was enhanced to 6,500 rupees with effect from 1/6/2001. The para 6 of the scheme is applicable to every employee. Who are those employees? Who become the member of the EPF scheme on or after 16 EPF scheme on or after 16/11/1995. Who was a member of the employees pension scheme in the scheme of 1971. Who ceases to be a member of the employees panel scheme and opt to exercise his option under the scheme. Who was a member of EPF or PF of the factories and establishment exempted under section 17 of the EPF Act, not being a member of the employees pension scheme, opt to exercise become member of the scheme. So, in other words, these were the 4 categories of people who are entitled to be covered under the pension scheme. Para 7 of the pension scheme provides option for joining the scheme. Members referred to at 3 and 4 above exercise option within the 6 months from, in other words, first 2 categories, it is automatic. Once the scheme was promulgated, they became members of the employees pension scheme automatically. In other words, it is mandatorily they were members. Whereas the option was available only in relation to category 3 and 4. Then what was this thing? Scheme what enhances the pattern of pension? The original scheme of 1995 enacted 2 kinds of pension patterns which are as follows. One based on the wage ceiling of 6,500 per month. In other words, the maximum contribution to the Provident Fund was 6,500. Out of the 12% of 6,500, 8.33% was being diverted to the pension fund. Then what was the another base? That means another pattern was based on a higher salary exceeding the wage limit of 6,500 per month, for which the contribution of higher salary exceeding wage ceiling were to be made in the pension fund, subject to exercising the option within a period of 6 months from 16/11 to 1995. However, even before the expiry of the aforesaid option, EPS was further amended with effect from EPS, that is Employees Pension Scheme, was amended with effect from 16/3/1996, dispensing with the 6-month period for exercising the option. However, the amendment dated so and so was not given wide publicity. This was basically crux of the problem which gave to all the grievances which were canvassed before the different High Court, and ultimately it reached the Supreme Court on 2 occasions. One, challenge to the decision of the Himachal Pradesh High Court in the case of R.C. Gupta, and all other cases in the case of decision of the Rajasthan High Court, Delhi High Court, and another High Court. So that was what it was. But kindly note in this, although here it is necessary to note that there was no, even after the amendment or the salary limit was enhanced, etc., there was no requirement of employees contributing higher salary or a higher quantum to the Provident Fund. Now the employees were requested to contribute more than what they have been contributing prior to 1/9/2014 or the pension from this time. So these particular things are to be noted. Thereafter, how the first case which arose in the matter is that of R.C. Gupta. What really happened in this case was that R.C. Gupta and others, including their employer, were contributing to the Provident Fund over and above the statutory limit that was prevailing as on that date, this thing, without being aware of the amendment dated 16/3/97, the employer took up the, that means they should have exercised the option immediately after 16/3/1966 to continue to contribute higher contribution and to diversion to the fund to the on the basis of the higher contribution made by them to the provident fund to the pension fund. But that had not been done. The entire money was lying in the provident fund account. Then the employers came to the rescue of the employees and they took up the matter with the Provident Fund Department with the permission to exercise the option and remit the contribution to the pension fund, because there was actually no requirement of remitting as that. The entire work had to be done by the PF department itself. The only requirement was that these people should have exercised that option, which was the requirement as per the amended provisions. So that has not been done. Then the Provident Fund Department clarified, they rejected it and clarified that employer and the employees can exercise the option to contribute to the pension fund on salary exceeding basic on two occasions, namely immediately on or from the date of commencement of the scheme, that is 16/11/1995, or immediately on and from the date of salary exceeding the statutory limit of 6,500, the then prevailing limit. That means it is only these two occasions. You can't do it at a later date. That was what the decision of the Provident Fund was. Then they did not stop this. They also clarified that the PF department further clarified that it is clear that the establishment is required to remit the contribution on the salary over and above the statutory limit from the month in which the salary crossed the limit, not from any later date. These employers, though had contributed, they took up the matter for exercising the option only at a later date, and this was rejected by the Provident Fund Department, and they said required that contribute on higher wages to pension. This was clearly contrary to the amendment of 16/3 of that one. This was contrary to the amendment of the scheme itself. The stand of the PF department was contrary to the what was stated in the scheme. Agreed by the rejection of the request, R.C. Gupta and others challenged the direction of the EPFO by filing writ petition in Himachal Pradesh High Court. The learned single judge of Himachal Pradesh held that the employer would be entitled to the benefit, the employee will be entitled to the benefit of deposit of 8.33% of their actual salary in the pension fund, irrespective of the ceiling limit. Kindly mark the word actual salary. They have contributed, if it is 18,000, they have contributed 80,000. If it is 40,000, they contributed on that. If it is 1 lakh, they contributed on that. The division bench of the Himachal Pradesh unfortunately reversed the order of the learned single judge, against which special leave petition was filed in the Supreme Court by R.C. Gupta and others. Thereafter, the Honorable Supreme Court in its judgment dated 4/10/2016 set aside the judgment of the division bench and upheld the judgment of the learned single judge. It is a clear indication that it is not the wisdom is stored only in the two persons. Even one person had the wisdom, his wisdom was upheld by the Supreme Court. The Honorable Supreme Court, while allowing the appeal, inter alia observed as under. Kindly note this is a very important observation. The reference to the date of commencement of scheme or the date on which the salary exceeds the ceiling limit are dates from which the option exercise ought to be reckoned for what? For the purpose of calculating the pensionable salary. The said dates are not cut-off dates to determine the eligibility of the employer and employee to indicate their option. Cannot be cut-off date at all. That was the contention. The fact is that the employer as well as the employed had contributed to the Provident Fund over and above the statutory salary limit. However, only 8.33% employer fund up to the statutory limit had been remitted to the pension fund. In other words, the difference between the 18.3% of the actual salary and the statutory salary limit was still lying with the provident fund people. Next question. Then again, there is another development. Yes, here. However, the further observations, I kindly go to the next slide, where you will find what are the other observations made by the Supreme Court in the matter. A beneficial scheme ought not to be allowed to be defeated by reference to the cut-off date, particularly in the situation where, as in the present, the employer has deposited 12% of the actual salary and not 12% of ceiling limit of 5,000 or 6,500 per month, as the case may be. Consequent to upholding of the claim, the Provident Fund Company should adjust the amount from the employer's portion of contribution 8.33% to the present extent of additional contribution over and above the statutory limit to the pension fund, which would enable the employees to get enhanced pension. So this was what the R.C. Gupta judgment came. Then what happened was, before R.C. Gupta judgment came, even before the judgment was delivered in R.C. Gupta and case, the Government of India, by notification dated 22/8/2014, raised the salary limit for coverage under the EPF Act from 6,500 per month to 15,000 per month, and the same was to be effective from 1/9/2014. Then there were other consequential amendments also. The notification data also brought certain other modification to the employees' pension scheme, mainly restricting its coverage with the following amendments to para 6 and 11. Pensionable salary shall be calculated on an average of 60 months salary. It was enhanced from 12 months to 16 months, 60 months. New membership to the pension fund was restricted to rupees 15,000 per month. Members' pensionable salary was rupees 15,000. That is the maximum ceiling limit. Then here, the consequence of these amendments are that those who join the service and become the members of the EPF scheme on or after 1/9/2014, they shall not be entitled to become pregnant, provided they are drawing their basic wages as defined under section 2B of the EPF Act, beyond 15,000. If they were drawing beyond 15,000, they were not entitled to become members of the pension scheme. So this was the major change that has been brought out in that amendment. Of course, there is no quarrel over it. This has been implemented. There is no grievance in respect of those excluded employees. So the grievance is only in respect of the others who are drawing below 50,000 or exempt, or who continue to contribute to the fund beyond 15,000. Then further amendments are that subpara 4 of the inserted 11 of the section 11(4). The existing members on the first day of September 2014, who shall be at the option of the employer and the employee, it is a joint option, had been contributing on salary exceeding 6,500 rupees per month, may, on a fresh option to be exercised jointly by the employer and the employee, continue to contribute on a salary exceeding 15,000 rupees per month. Fresh option shall be exercised by member within a period of 6 months, effective from 1/9/2014. Aforesaid members have to contribute 1.16 on a salary exceeding rupees as additional contribution from and out of the contribution payable by the employers. Then that paragraph 11.4 also provided also that the period specified in the second provision on a sufficient cost being shown by the member be extended the region by the region by a further period of not exceeding 6 months. But that was removed. Provided also that if no option is exercised by the member within such period, including the extended period, it shall be deemed that the member has not opted for contribution over and above the wage ceiling, and the contribution to the pension fund made over the wage ceiling in respect of the member shall be diverted to the provident fund account of the member along with the interest as declared by the employees provident scheme from time to time. So this was the effect of that amendment. Then the consequence is that if they fail to exercise the option, even if they have been already contributing to the provident fund on actual salary basis, that benefit also was gone only on the ground that they have not exercised the option within the period specified under the act, that is the 6 plus 6 months that they have not exercised, so that has also gone. Then this was the cause for a litigation before the different high courts and Kerala, Rajasthan and Delhi. These are, and the high courts held that the amendment are unconstitutional and hence stepped down. The High Court further held that the employee shall be entitled to exercise the option without insistence on the cutoff dates, additional contribution, and order to pay pension by calculating 12 months average pay and actual contribution. Here, kindly mark the word actual contribution. Pension by calculating 12 months average pay and actual contribution. The High Court also held that the decision will not be applicable to exempted establishment. You know, this is one thing very controversial. The Employees Provident Fund Organization filed a special leave petition before the Supreme Court challenging the judgment of Kerala, Rajasthan, Delhi High Court in the case EPFO versus Sunil Kumar in CSA, which was decided on 4/11/2022. What are the issues considered by the Supreme Court while considering the case report that is in the Sunil Kumar case? Calculation of pensionable salary at average pay for 60 months preceding date of exit instead of 12 months will reduce the pension amount. Fixation of maximum pensionable salary ceiling at rupees 15,000 rather than the actual contribution made by the employers to the provident fund. Employees to the provident would deprive the employees the decent pension. Fixation of time limit of 6 months for members to file the fresh option would defeat the very purpose of the beneficial scheme. Additional payment of 1.16% by employees as additional contribution for members who want to contribute more than the statutory salary limit, salary ceiling. Here I may pause for a minute with regard to this 1.16%. You see, this was the contribution which was being made by the government of India to the employer family pension scheme when it was introduced in the year 1971. But with the introduction of the pension scheme in the year 1995, Government of India said we will not contribute anything to the pension fund of the employees covered under the Provident Fund scheme. So this 1.6 is, and how they have calculated, it is probably on the basis of the actual committee of the EPFO. Whether the scheme will be applicable to the exempted establishment also. Validity of the directions issued. Validity of the directions issued by the Supreme Court. Validity of the direction issued by the Supreme Court in the case of R.C. Gupta and others. The Supreme Court in its judgment dated 4/11/2022 held that the provisions contained in the notification dated 22/8 to the are legal and valid, but some provisions of scheme have been read down in favor of the employees. Here is a victory for the department that it is able to have the notification upheld. Amendment to the pension scheme brought about by the notification dated shall apply to the employees of the exempted establishment in the same manner as the employees of the regular establishment. Transfer of the fund from the existing establishment's trust shall be in a manner as we have already directed. That is whatever the excess was there owned above the statutory limit contribution, that has to go to 8.33% of that shall have to go to the pension fund, and the pension fund is managed by the Provident Fund Department even in case of exempted establishment. So therefore that amount will be remitted to them. The employees who had exercised the option under the provisionary paragraph 11(3) of 1995 scheme and continued to be in service as on 1/9/2014 will be guided by the amended provisions of 11(4) of the pension scheme. The members of the scheme who did not exercise, this is more important. Kindly note those people who will be affected who are not exercised. The members of the scheme who did not exercise the option as contemplated in the proviso to 11.3 of the pension scheme, as it was before 2014, would be entitled to exercise the option under paragraph 11(4) of the post-amendment scheme. The scheme as it stood before 1/9/2014 did not provide for any cutoff date, and thus those members shall be entitled to exercise option in terms of paragraph 11(4) of the scheme as it stands at present. Their exercise option shall be in the nature of the joint option covering the pre-amended paragraph 11(3 as also amended paragraph 11(4) of pension scheme. There was uncertainty regarding validity of the post-amendment scheme, which was quashed by the judgment of the 3 High Court. Thus, all the employees who did not exercise the option but were entitled to do so, but could not do due to the interpretation of the cutoff date by the authorities, ought to be given a further chance to exercise the scheme. Time to exercise the option under 4 of the scheme under these circumstances shall stand extended by a further period of 4 months from the date of judgment, that is 4/11/2000. Here I pause for a minute. See, one more thing which we have to understand this paragraph better is that under paragraph 26, the clause 6 subsection says it empowers that the employer and the employee may contribute on a higher salary than the statutory limit to the provident fund, but there are 2 conditions that are to be satisfied. The first and foremost, the employer as well as the employee should make a joint application to the Assistant Provident Fund Commissioner or the other authorities concerned, seeking their approval to make contribution on actual salary of the higher. Secondly, the employer should undertake that they will pay the administrative charges on account of this additional contribution. So these conditions should be satisfied. If they are already made such a declaration before opting for they making a contribution on actual salary, this 11(3) and 11(4) would also beneficial to them. They can exercise the option. But if they have not exercised such option under paragraph 26.6, then they will not be able to do so under the amended scheme. So this particular aspect should be kept in view by those people who are going to exercise the option in accordance with the judgment of the Supreme Court, present judgment of the Supreme Court. In other words, it may be specifically noted that satisfaction of paragraph 26 and subsection 6 is a mandatory thing to get the benefit of the recent judgment of the Supreme Court. Then the employees who had retired prior to, then they come to the other thing, nitty-gritties. Employees who had retired prior to 192 without exercising any option. Kindly note this wording. Without exercising any option under para 11.3 of the pre-amended scheme, have already existed from the membership thereof, they would not be entitled to the benefit of this judgment. Most of the queries we are receiving is under this paragraph, and unfortunately, they are not entitled. The employees who have retired before 192 upon exercising option, they already exercised the option, scheme shall be covered the provisions of paragraph same as it would prior to the amendment of 2014. The requirement of members to contribute at the rate of 1.16% of their salaries to the extent of such salary exceeds rupees 15,000 per month as an additional contribution under the amended scheme is held to be ultra vires the provisions of the Act of 1952. The operation of this part of the order will, however, be suspended for a period of 6 months in order to enable the authority to make adjustment in the scheme so that the additional contribution can be generated from some other legitimate source within the scope of the Act, which may include enhancing the rate of contribution by the employer. You see, this is one sentence which may enhance the financial liability of the employer towards the provident fund contribution in the event the Government of India amends the provision to provide for payment of 1.16%, whichever. So this is one thing that has to be kept in mind. Legitimate source within which could, for the aforesaid for a period of 6 months or till such time any amendment made, whichever is earlier, the employer's contribution shall be a stopgap measure. The said sum shall be adjustable on the basis of the alteration in the scheme that may be made. In other words, meaning of this sentence would be that in the event those who are making on actual contribution, they continue to make actual contribution as it was being heretofore, then an additional contribution of 1.6%, that means that upholding of the rather striking down the provision relating to contribution of 1.16% by those employees who opt to make contribution to the provident fund on the basis of their actual salary will also be liable to pay additional contribution, but this will be adjusted once the legislative measures as contemplated under the judgment of the Supreme Court are in place. Then the then the court further observed that we cannot ignore the fact that the pension amount to be paid has been calculated on projection that the corpus would be include an option of employees additional contribution 1.6%. We also cannot mandate the central government to contribute to the pension fund scheme in the absence of legislative provision to add to that effect. It would be for the administrator to readjust the contribution pattern within the scope of the statute, and one possible solution would be the rise in the level of employees' contribution in the case of employees who are contributing to the provident fund on actual salary basis. In other words, you see, you must also note that there is no provision in the either in the PF Act or in the PSB or in the pension scheme itself that the employee should make direct contribution to the pension fund. The pension fund corpus comes from the provident fund contribution itself, and once it is contributed, they out of that employer's contribution of 12%, 8.33%, it may be on actual salary or on the statutory limit only, will be transferred to the pension fund. That forms the corpus of the pension fund. So that is it has come in the context of that. No flaw could be done in altering the basis of computation of base. That is 60 months salary. 60 months salary, you see their justification given by the Provident Fund Department before the Supreme Court was that it has been 60 months has been calculated on the basis of on the ground that it will take into account the fluctuation in the salary. Normally, an employee at the end of his career will be drawing higher salary than this thing actually. So previously it was only 12 months. It was again enhanced by 5 times. It has taken to 60. So that means during the last 5 years, whatever the salary he had taken, that is the average will be taken into account for the purpose of determining the pensionable salary. So definitely it may be advantageous it may not cause so much disadvantage to the employee, but 12 month salary would have been a burden on the PF department or the pension department as the case may be, because during those 12 months, last 12 months of one salary, generally a workman or an officer will be drawing much more salary than many of them. Wherever scale of pay is there, they will be at the end of their scale of pay, or they will be getting that stagnation increment and other benefits like that. Those who have completed the period to which the scale relates to. So such being the process that will take up. The fund authority shall implement the directives contained in. You see, this is important. The fund authority shall implement the directives contained in R.C. Gupta and their case within a period of 8 weeks, subject to our direction contained in the earlier paragraph. Court has agreed with the division bench interpretation of the proviso to the pre-date amendment pension scheme in the state. This we must read the division bench interpreted. Division bench is not that of the Kerala High Court. Himachal Pradesh High Court. It is the division bench decision of the Supreme Court itself. So that division where they are interpreted, that means what is no work is involved. What the Provident Fund Department is to do is like in the R.C. Gupta and other case, the money was already lying in the Provident Fund account. Excess contribution made by them. That excess contribution made by them over and above the statute limit shall have to be remitted to the pension fund, which will enable them to draw enhanced pension. That was all what they said. So this is how it is. Then judgment will be applicable to those of the members of the Provident Fund. Implication of the judgment, we will just go to the implication of the judgment. The judgment will be applicable to those members of the Provident Fund who had given option to become pension scheme under paragraph 11.3 of the pension scheme prior to August 2014 and continue to be the members as on 1/9/2014 also. The members of the pension scheme who had joined on or after 1/9/2014 are not entitled to get higher pension, and the judgment is not applicable to them. That means in respect they will be drawing this word with but subsequent to that, the requirement of making additional contribution of, you see here this paragraph, this particular, the members of the pension scheme who had joined on or after 1/9/2014 are not entitled to get pension higher than, because from 1/9/2014 this concept of making over and above contribution to the fresh members was not at all applicable. It was applicable only to those members who are the members of the pension schemes and who had exercised the option under paragraph 26.6 were only available to exercise the option which is now available under the amended scheme which came into force from 1/9/2014, not earlier. This aspect should be kept in view. So that is what this para, the members of pension fund who had joined on or after 1/9 are not able to get higher pension, and judgment is not applicable to them for the reason that they are not entitled to become the contribute over and above rupees 15,000 to the pension fund, even if their salary is above and even if they are contributing to the provident fund on actual basis. In any way, they will not be losers, because when once the money will be lying in the provident fund account, it will not go to the pension fund account. They will get the refund along with the interest. The requirement of making additional contribution 1.6 by the members of the pension who have contributed over and above per month has been struck down. However, this portion of the judgment has, yes, this I have already pointed out to you, so I will skip it. Time limit for exchange has been extended by 4 months, effective from the date of judgment. Then, implications of the judgment. The members of the pension fund, members of bank who had joined on or after 1/9/2014 are not entitled to get higher pension, and the same for them judgment is not applicable. The direction of the Supreme Court in the case of Aarti Gupta and others shall have to be followed by the Provident Fund organization, because the money is lying with them. Consequent to enhancement in the salary limit for the coverage under the EPF scheme, it is clarified by the FO that the employer and employer can exercise the option to contribute the pension fund on a salary exceeding base ceiling on 2 occasions, immediately on and from the date of commencement of the scheme, and immediately on and from the date on which exceeded statutory limit of 6,500 per month, then prevailing rate. If you have salary clauses 15,000, etc., unless you are a member of the fund, you will not be entitled to because you are one who joined. Say, let us say one employee who joins here today, and though he may be made coverable under the EPF scheme on a salary above rupees 15,000, he cannot be made to as a member of the pension fund. Then immediate all this is over. Then thereafter, the judgments, as the judgment stands, does not impose any additional financial liability on the employer, but there are certain administrative work which the employers shall have to necessarily undertake. One is that they have to become the joint option that has to be forwarded to the PF department. Then, in the case of the employees who are already retired from the service, and if they are covered under the is an exempted establishment, they have to calculate between the amount which is being actually payable to the pension fund on the basis of judgment and remit that amount along with the interest to the fund. There had been also a question today by one of the members saying that whether I am liable to pay damages because I am remitting it now. The answer is no, because there is no default or delay in remitting the contribution. The damages will be payable only if there is a delay or default in remitting the contribution. So here it is not, the fund is already contributed, accounted for, informed the Provident Fund Department, everything, it is complete. So there is no question. Now you are remitting it because of the just judgment and to confer a benefit to the employees themselves. So damages will not be paid, but the trust shall have to pay the interest as it was paid to them during the relevant period and add to the contribution and remit it to the Provident Fund Department. Then let us take one or two calculations as to how the pension is to be calculated. Sample of calculation. You see, let us assume for the sake of argument, an employee has completed 19 years of service up to 31/8/2014. That is prior to enhancement of the salary ceiling and other amendment. that is on a contribution on 6,500 only. Another 6-year service on 1/9 from, that is second part of the service, 1/9/2014 with a contribution of 13,725. Then he ceases to be the employee or that he retired from the service as on 31/8/2020. In other words, he has done how much service? 19 plus 6 years, 35 years service. 20. 20 years, 25 years service. Actual service up to this thing, etc. 19, that is only on 6,000 rupees divided by 70. This 19-year service, that is pensionable service, salary, pensionable salary divided by 70 in accordance with the formula of the prescribed on the pension scheme. So that is the amount of gratuity payable is 1,764.28. Actual service from 1/9/2014 to date of exist, 6 years. Then actual salary 13,720. That was about the statute limit of 6,500. This thing, etc. 2-year weightage period. You see, 2-year weightage period, yeah, pensionable salary is not to be calculated on actual salary. It is to be calculated only on the statutory salary limit. And the 2 years is not available to each and everyone. The one who has completed 20 years or above, and he gets only 2 years. That this 2-year period will also helpful not only these people, those who retire after 58 years. So he will get the pension as if he had completed 6 years service because of the benefit of 2 years. Weightage period available to him in the event he has completed 20 years service and he retires on attaining the age of 58 years. Then total pension payable will be 3,141. Now let us take an example. When you have made an actual basic pay throughout his career, and that means particularly those who are the that higher salary, higher bracket salary people. You see, he has been we have assumed a period of service for 35 years. For all 35 years of service, he has contributed on actual salary of rupees 1 lakh. He also satisfied the following conditions because that is a prerequisite for claiming higher pension. He has been a member of as on 1/9/2014. That means he was already a member of 2014 pension scheme on the date from the date of his appointment or the exemption and continued to be so. He contributed on actual salary after exercising the option under 26.6. He had also exercised the option under 11.3 before 22/8/2014, or he has exercised the option within 6 plus 6 months under 11.4, or he has exercised such option within 4 months, that is under the judgment. Within the 4 months under that, as per the judgment of the Supreme Court. If all the above conditions are satisfied, he has the benefit. He will be eligible for a pension as under 35 years, 1 lakh divided by 70, total pension payable will be 50,000. Say, let us assume a situation where he unfortunately dies. Then his widow or the other dependent family members will get 25,000. So this is the benefit which flows from this judgment. So the pensioners shall have to take a view whether to opt for the judgment or not, this thing, etc., by calculating each of the cases. You see, it will not be a very advisable proposition to proceed on a basis that this judgment is available to all the pensioners. That may not be the actual case. Firstly, the cutoff date has been given as those who are retired prior to 1/9/2014, they are not entitled to. Secondly, if they are already retired from the service without option, obtaining the option under 26.6 and also without contributing, making any actual contribution on the actual salary to the provident fund, they will also not be entitled to. So all these factors shall have to be taken into account before deciding whether to opt in accordance with the judgment, particularly those of the employees who have already retired from the service and who are no longer in service, because they shall have to pay, they shall have to refund the amount they have received from their provident fund to the provident fund department, along with not only the contribution but all the amount received, but the interest payable for this period. The period from the date of retirement up to the date on which they repeat, that too it is to be done within 4 months. So this is all the month. Thanks one and all. So we will be taking some question, and we have compiled some questions which Madam Rupa had forwarded to us, which she had received. So there are several questions, but most of them are repetitive. So we will be answering only selected questions which would cover the judgment, etc., and particularly only on the basis of this judgment, because we will not be able to answer any other things which are not related to discussion of today. Thank you, Honorable Sir.
Thank you. Thank you very much, Gowda sir. It was a very, very exhaustive presentation with regard to the pension, that is the Supreme Court judgment on the pension, and also the eligibility of who is eligible to receive this pension, who is eligible to actually take the benefit of this judgment. So three things stand out very, very clearly from the presentation of Gowda sir. One is the person must have been a member as on or before 1/9/2014. That is the first condition, what you call as condition precedent to receive this benefit of this judgment. If you ask yourself, these three questions you will have to answer. First, whether you are a member on or before 1/9/2014. If the answer is yes to that, second question would be whether you have contributed on the actual salary after exercising option under 26(6). That is, whether you have opted for or taken permission to contribute on a higher salary than the statutory salary by submitting a joint application both from your employer and yourself before this date, that is 1/9/2014. That is the second question to answer. Then the third question to answer is, having exercised the option under 26(6), whether did you exercise the further option under 11(3), that is before 22/8/2014, did you exercise the further option of transferring the contributions made over and above the statutory limit to the pension fund? That is option under 11(3). If you did not do it, you were given one more chance after 22/8/2014 under 11(4), wherein you are given a period of 6 + 6 months time to exercise that option once again. If you did not do that even then, you get one more chance now thanks to this Supreme Court judgment. This is in a nutshell, the entire story of this pension scheme as far as the Supreme Court judgment is concerned. Now, going to the questions, as Gowda sir said, almost all the questions are connected with, have been answered by the presentation made by Gowda sir. But still, for the sake of clarity, we will take up a few questions, just in case if there is any point that has not been made clear by Gowda sir's presentation. The first question I'm going to ask Gowda sir is, employees who are not a part of pension scheme, are they eligible for this scheme? Do they get an option to enroll in future? Is there any possibility? They are talking of the future. Is there any possibility of enrolling into the pension scheme that we just described in future?
So as the pension scheme stands and as decided by the Supreme Court, there is no scope for people who are not the members of the Provident Fund and the pension fund and who are no longer in the service, or who are even, it cannot be those who are not the members of pension fund cannot be they in service, because the pension fund has come into force from 16/11/1995. So it will basically, a question appears to be from a person who is no longer in the service. Unfortunately, he is not entitled to become member as the law stands, as the provision in the scheme stands.
There is one more interesting question. I will take this question, although it does not entirely relate to the presentation made today. But this is a question which is exercising the minds of many participants. Therefore, I am going to ask this question. Minimum pension under the PF along with the criteria. That is the first part of it. Then calculation of pension under PF, calculation of pension under NPS, which gives more returns, or use of superannuation scheme given by LIC or others. How much and where a person needs to save and maintain the same standard of living after attaining superannuation.
So minimum pension scheme formula, etc., has already been stated. That is on the basis of the this one and etc. and 3,000. 1,000, 3,000. Minimum pension. Minimum pension is 3,000 rupees. That is for the people who are getting less than 15,000 per month. That is one thing. Those who are getting anywhere between 15,000, less than 15,000 or 15,000 only, the quantum of pension payable is on the basis of the pensionable service, pensionable salary divided by 70. So that would give the pension payable to the employee concerned. But at the same time, if they have acted for actual contribution, then the quantum of pension payable will definitely be higher. At the same time, we cannot undertake the exercise of comparing with the two other schemes, NPS as well as the annuity scheme available with the LIC, because they are under different concept, etc. So we will not be able to deal with it in this session. But if any of the members were to have a distinct idea about that, they can make a reference to us. We will definitely examine and answer them.
Thank you, sir. This question is a general question, and although it has been answered, I will repeat it once again. Can a person who has not opted for higher pension earlier can opt for higher pension now? What is the pension calculation formula?
That is not available. It is only, the judgment is applicable only to those people who have, they think have been members of the pension fund and have been contributing the provident fund on the actual basis.
As
So
on
that's
as on 19/2000.
as on 1/9/2014. So that will not be applicable to this. In case he had been whatever the reason case, he had not become member. No, he can't become a member now. That is not the intention of the event. That is not the intention of the pension scheme itself.
One more question. Employee has been contributing to pension fund since 2010. Though his employer is contributing to PF on full basic wages, the contribution to EPS was restricted to ceiling limit. That means for the pension, it was restricted to ceiling limit, whereas for the fund, that is provident fund, it was at the full basic wages. And the difference contribution was also contributed to EPF account, as was practiced by most organizations. Now, is there any impact for such employees? If so, what they need to do now?
Yes, definitely he will be benefited. It means that if he was contributing over and above the standard, he had already exercised the option under paragraph 26.6. So when once he is expired, the judgment is available, and in terms of the judgment, he can definitely obtain option and then request the Provident Fund Authority to transfer the excess amount remitted to the Provident Fund to the pension fund. That is excess amount with the 8.33% contribution made by the employer. There is no need for the employer to make any contribution at all.
Thank you, sir. One more question. From the date of incorporation, we are paying pension amount with RPFC even though all employees are more than PF ceiling amount, any changes or impact by this judgment or any action to be performed by us. So from the date of incorporation, we are paying pension amount with RPFC, I think on statutory limit. Even though all employees are more than PF ceiling amount, any changes or impact by this judgment or any action to be performed by us.
No, that means if they have been contributing on actual salary, after exercising that joint option under 20.6, they can even now try for this thing pension. But
Earlier question,
but if they are not exercised option, simply remitted to the Provident Fund Department, the amount will be lying with the Provident Fund Department only. They cannot avail the benefit at all. The only thing is that employee will not be caused any prejudice because if they would get the entire outstanding in the Provident Fund Commission or the Provident Fund on retirement.
I will take this question from Pranay Saran. I was part of exempted organization, but they were not remitting any amount to the pension fund, but they were deducted the amount on actual salary. Now, this question pertains to an exempted organization. I think Gowda sir can answer this question.
Yes. That means it was a case, what is the date of your appointment? You see, it depends upon when you join the environment. Suppose if you are joined after 1/9/2014, definitely you are not entitled to become member of the pension fund. So they need not remit any amount to the pension fund, they have a right. So it is not this thing, you will not be entitled to get the benefit. So first check out what is the date of your appointment.
Now, with regard to the example that we gave, this question says, in the example, the employee has contributed for the last 6 years at higher pay, that is 13,000, etc. Is there a need to consider the average based on 6,500 since last 60 months average is on higher pay?
No, there in this case, there were two types of contribution. One on the statutory salary up to a given date, and thereafter he has contributed higher. So that was calculation shall have to be made according to in terms of calculation. And there is a circular issued by the PF department itself, central office of the PF organization, as to how to calculate in case of the pensionable salary in respect of those employees who have contributed only up to standard and thereafter contributed on higher amount.
This question, the offer letter and appointment letter of the organization says that the PF will be made on actual basic and the company will contribute equal amount for which employee accepts the offer. Will this be considered as a declaration?
No, I mean, yes, it may be, but what is the date of appointment again? And again, whether that means it is if you look at the terms in the offer letter, it is obviously a case letter of appointment issued after 1/9/2014. So they are correct.
Yes. So the question is the cutoff date is very important. That is 1/9/2014, number one. And number two, your offer letter of appointment stating that you have contribution will be made on the actual salary cannot be considered as a declaration because there is a separate declaration that has to be made under 26.
It is not a the declaration in the contract of employment. It should be a declaration signed under para 26 point, and this declaration may not arise in the case of the gentleman because as far as the Provident Fund is concerned, that contribution can be made even for that excess contribution. It is necessary to exercise the option under paragraph 20.6. That is necessary. Option is necessary, and the employer should agree for bearing the administrative charges. So that formality they must have completed it, probably whether the employee himself may or may not be knowing what the exact format comes. Otherwise, trust being the exempted establishment, they would not default in ensuring statutory compliance.
Is there any provision for increase in pension for members who are part of EPS 2014, attained age of 58 but not started their pension. So they are already members of EPS 2014, attained the age of 58 but not yet started their pension. Is there a provision to increase their pension?
But that means actually what was the contribution made, whether they are made on actual salary or on the basis of the statutory limit.
Exactly. So you will have to go back and see whether as on that date you have you are actually making contribution on a higher salary. Number one. Number two, did you make the declaration under 26(6)? Number two, and number three, whether you made the further declaration under 11(3) or 11(4). If not, whether you can do it now. Only then you will be able to enjoy the benefit of higher pension. Now, one more question here. This is a very general question again. Is this beneficial to opt for this scheme? Is it beneficial to opt for this scheme? Any comparison of pension with this scheme without this? Is it okay? The question is only this. Is it beneficial to opt for this scheme?
Actually, this may be beneficial in respect of those people who have made on the actual contribution that to higher amount, like the one which we gave 1 lakh example. So it has to be worked out in respect of each individual case, because that in case he has already retired from the service, then he has to determine what is the quantum of amount he has to refund and what is the advantage he is going to get by getting the additional pension. So these are the things it has to be calculated in respect of each and every question. It is not possible to make a general statement that it is applicable to all the pensioners, irrespective of their distinct date of retirement, etc. No, it is not. We have to examine each and every case. And another thing aspect which they have to control, if they were to make what is it gain? If they were to remit it now a huge amount towards the amount already along with the interest, and in the event something else happens, unfortunately happens to him, his family is unlikely to get the benefit which was or would have accrued had they invested in the other investment like bank deposit or any other interest bearing deposits.
This is, you can take
Just
one more question.
Just one more question.
Over.
Yes,
Last
yes, this is the
Last.
yes, sir, yes, sir. This will be the last question. Again, an interesting question. This is with regard to a person who has already retired. Whether an employee who has already retired will be allowed to submit a joint declaration to increase the pension on the actual salary, assuming that he has complied with all the three conditions.
Yes, you can do so. Within 4 months you have to.
But then there is implications, that is, you will have to refund all the amounts that you have already withdrawn and with interest.
No, then again he has to calculate. You have to calculate what is the going of advantage which is going to accrue in the event you are, and you in the event you refund the amount with interest, etc.
In fact, I understand there are a lot of other questions also. See, this shows that the judgment has left a lot of people in confusion. Now, with regard to balance questions, you can either send it to Bangalore Chamber of Commerce or to Karnataka Employees Association. We'll give answers to that. And many people have asked for the presentation of PPTs. That also will be sent. Whoever wants it, they can make a request. It will be sent to them also. So thank you, Mr. Augustus. You can take over now.
Yeah, thank you, sir. I would now request Dr. Augustus Azaria to take over. No introduction required of Dr. Augustus, a very eminent personality and a very erudite personality. And I would request him to sum up and also deliver the vote of thanks.
Sir, Dr. Augustus has to jump in for another call. We now request Mr. Parshuraman, our past president, to sum up and deliver the vote of thanks. Over to you, sir.
Thank you, Rupaji. Good evening, all. Once again, I would like to thank my heartfelt thanks to Mr. Prabhakar, Chairman of KEA and team. I think Mr. Gowdaji had done a wonderful job along with his partner, Mr. Vasuki. I think it was an exemplary session, I would say. Rightly said by Mr. Prabhakar, I think the kind of clarity that is required is something enormous here, because too many ifs and buts. And as rightly said by Mr. Gowda, I think individual case by case, it is very, very important to understand the risk, because it is a very complicated thing. Again, many factors are involved. When the employee is retired, or how long is the service, or when did they start the contribution, whether he has removed the funds. I think many things are happening. I think one of the interesting questions that is coming, sir, time and again today, I think I could see the chat box. If an employee has not opted, but he has been paying on the higher service, higher pension, if he has not opted, then I think they are not eligible. That is coming out very clearly today, which means that window is not openable now, because there should have been a joint declaration between the employee and the employer to opt for higher pension. I think this 26/6, whatever is that provision, I think, am I correct, sir? I think that is the kind of chat box.
Yes. If they had not exercised the option, and they cannot exercise it now, the option cannot be retrospective at all, except to the extent of that 4 months gap, the gap provided by the Supreme Court judgment. So that is for the purpose of exercising option in accordance with the amended paragraph of 11.4 or 11.3 as the case. But they should have first exercised option under paragraph 26.6. So unless they have exercised, simply remitted the money to the Provident Fund Department, the money will be lying with the Provident, they will refund. They have already refunded probably. So they cannot opt for higher pension at this point of time.
I think this is a very important clarification, because most of the people sitting on this category is much higher, because they're all thinking that people have deposited the money in the Provident Fund, and it is possible to transfer from Provident Fund to Pension Fund. So I think today it is very clearly brought by the speaker and expert that it is not possible at this point of time. And the window openable now, 4 months, is then what, sir, actually?
That is for the people who have remitted on actual basis and who had exercised option under paragraph 26 point. They can now exercise a further option for making additional contribution to the pension fund within 4 months.
Means earlier
they have contributed on actual basis to the Provident Fund, but whereas the remittance to the pension fund has been only on the basis of either 6,500 or 15,000 after 1/9/2014. So that therefore 15,000 only, that is the limit. But if they had actually made up on the basis of the declaration made under paragraph 26.6, then definitely they are saved. They are entitled to seek for remitting the additional contribution made by them to the pension fund and draw enhanced pension on the said basis.
So 26.6 is the declaration.
It is a precondition, sir. It is a precondition for making additional contribution to the product. Even in case of executives and etc. who are making on actual basic pay, maybe the 50,000, 60,000, 1 lakh, 1 lakh, anything would be there.
Sir, may I also make a small clarification here? Continuing where Dr. Gowda sir said, it is basically a two-step process. Step number 1 is 26.6 declaration. What does 26.6 declaration do? It enables the contribution at a higher rate towards the Provident Fund. We have two different funds here. We must remember that. One is the Provident Fund, one is the Pension Fund. Now, the first step, that is what we call as the condition precedent, is that you decide to contribute at a higher rate, number 1. Higher rate than the statutory rate, number 1. Then you file a joint application under 26.6 to seek permission to contribute at a higher rate towards the Provident Fund. 26.6 refers to the Provident Fund.
I see.
Then there is a second step under 11.3 or 11.4, which seeks permission to contribute at a higher rate to Pension Fund. So now if you have chosen, if you have already exercised the first option, but because of non-clarity, you did not exercise the second option, this 4-month window period enables you to exercise the second option.
I think, sir, you have made it very clear, which means people cannot contribute on the higher salary to the provident fund without the 26/6.
Correct.
Yes.
26/6
Condition
is
precedent, sir.
it is a condition precedent, or
So
what
which
we call
means-
it as.
So the questions coming in the chat box, which means many companies are paying on the full salary to the provident fund. So which means those companies, those employees are eligible, provided they have a window period now for next 4 months to opt for higher contribution to the pension fund. I think it's very clear. Thank you, sir. I think, sir, today's session was a fantastic session. I think you spelled out so much of micro details. I think it is really a enormous task. In fact, I was just listening to the whole episode. I think you have done a fabulous job, sir. I'm sure still our members have got many questions. But as Mr. Prabhakar said, I think always the KEA is always a great organization supporting the employees. So from Bangalore Chambers also, I think I would like to definitely take it up and take it to KEA. Our good friend, Mr. Prabhakar, with always a helping hand. In fact, the way he has contributed to the industry, to the Bangalore Chambers, to the HR fraternity is mind-boggling. And still he is 75 years young. And
80,
still
80.
tirelessly working. 80, sir, sorry. Sir, you become younger and younger as the day passes. I think that is your beauty. So once again, I thank all the members. Today, the kind of participation, I am very overwhelmed because the number has crossed 250, close to 300 mark. I think this shows how important this topic is. So once again, I thank all of you. Thank Bangalore Chambers. In fact, on the behalf of my president, Dr. Ravindran, who is in South Africa, so he has also conveyed his best wishes. And this meeting is an amazing meeting. So I would love to continue this meeting maybe in the session 2 with more clarifications. I think with the permission of Mr. Prabhakar. So maybe I'm sure that it will rise to a lot of other new points. So we'll take it up later. For the scarcity of time, we would like to thank you all. And from Bangalore Chamber of Industry and Commerce, we will be sending the mementos to all the speakers today. I think that our office will be reaching it to your places as a small memento from our side. Once again, sir, thank you so much and have a wonderful evening. Thank you. God bless.
Thank you all. Thank you all.
Thank you very much, sir.
Thank you.